Hello, everyone. We apologize for any technical difficulties, but we had a little issue with Zoom. So hopefully I will post this in the other video chat. Hello, everyone. And we apologize for any maybe we can actually get this done. And of course, now you can hear me twice. Sorry for the echo. This is amazing.
What's going on, man?
Oh, I don't know.
It's one of those days.
Yeah. Streaming site.
End of the eviction moratorium. Done.
And of course, this is the end of my ability to do anything on YouTube and Zoom. But in my defense, it's been a while since I've been on, and maybe I forgot how to do it. So that's my story, and I'm sticking.
You're better than me, so not saying much.
But welcome, everyone. Hopefully you can join us. I understand there are some people waiting, and I do apologize for the any of the delays, but we will go ahead and get started. I am Ray Gertkin with Nevada Legal Services.
And I'm David Olshan.
And we are going to talk about the end of the eviction moratorium and what to do now that summary eviction, what to do now that it's over, and how to handle your summary eviction hearing and any potential issues with your hearing, the judge, and possible appeals. All right, so as I said, all the moratoriums have ended. The Nevada eviction moratorium ended on May 31st, and then the Supreme Court overturned the CDC moratorium, holding it unconstitutional on August 26th. As of August 26th, then there have been no eviction moratoriums in place. So, is there any way to stop an eviction at this point? In Nevada, Governor Sisolak did sign AB 486, which is designed to help renters who have applied for rental assistance stay in their units while the rental assistance applications are pending. There's been a lot of problems with rolling out the rental assistance programs, getting rental assistance paid to tenants. And because of that, they actually passed a law the last session providing help to renters so that they can stay in their homes while they wait for the application to be processed. So the main issue is you have to apply for rental assistance for this to apply to you. So first things first, apply for rental assistance. Again, this is a government agency that you need to apply for. And every, our last slide will show you the links to apply for rental assistance, but we're talking about, in Reno, the Reno Housing Authority, in Clark County Social Services. So make sure that you're applying for rental assistance from a government agency. And the big thing is once you make that application under AB 46, you have to actively pursue that rental assistance. So make sure you're uploading all of the documents that they ask. You're responding to any questions or queries about your status, filling out the appropriate forms. Make sure you're following up with the rental assistance provider to make sure your application is good to go and can be processed.
It's important to also kind of realize that even though you're going to a government agency, you're filling out these forms, you're applying for rent assistance, your 7-day notice is still there. So you're not really doing anything to address the 7-day notice, and you must file an affidavit after you apply for rent assistance.
Right. And make sure that you're putting in that affidavit, your defense that you applied for rental assistance and that you've been actively pursuing it. You've uploaded all your forms, you're doing whatever they asked you to do. Every self-help form has the ABC, I shouldn't say every. The self-help forms at the Civil Law Help Center and our self-help forms do have the AB 486 defense language in them. And our forms are on our website, nlslaw.net, and then obviously the Civil Law Self-Help-Center.org for Southern Nevada. So make sure, though, that you are checking the box, and all the affidavits have a space for you to add additional information. So you might want to throw in there that you've uploaded all the documents, you check the status, what you've done to actively pursue the rental assistance. If you do it, if you have applied for rental assistance and you've been pursuing it, then your eviction has to be stayed until the rental assistance is paid, or it's resolved in some way. If your application is denied, then you would have to go back in and have a hearing on your eviction. If your landlord doesn't cooperate with the rental assistance process or refuses to accept the rental assistance, then you have a defense to the eviction and it should be denied. But if you've applied and your landlord's willing to take it, your eviction is simply stayed until the application is either granted or denied. And your landlord can rebut the allegations regarding rental assistance, I guess saying you didn't actually apply or that you haven't done everything that's required to finalize your application.
All I can say is
the foreclosure thing I was going to skip, but go ahead.
No, it's just like it's kind of absurd to say I have a realistic threat of foreclosure and then deny rent assistance. And it's also hard to understand why, if this is a rental property, why anyone should really care if there's a foreclosure, but that's just my opinion.
Yeah, it's not the landlord's primary residence, and they should want the rental assistance so they can pay their mortgage. All right, so we've talked about active pursuit. In Southern Nevada, this has kind of been an issue. I don't believe it's really been that much of an issue elsewhere, but just make sure that you're checking on the status of your application regularly. Make a note when you do, saying I checked on X date and the status was unchanged. I think with Clark County Social Services, there is a potential to get more information on the status of your application and possibly contact them. Just make sure you're not missing any appointments, you're updating your contact information, and you're following through with whatever they're asking you to do. Make sure that, I would allege all of this in your tenant's affidavit. Again, the samples on our website and the Civil Law Self-Help Center, they have check boxes for you to check off that you've applied for rental assistance and are raising the AB 486 defense, but you might want to supplement them with a little bit more information about what you've done. And then at your hearing, make sure you are prepared with information regarding the status of your application, the notes of when you've contacted them, when you applied, that if the status is unchanged or they're still processing or whatever it is, just make sure you are prepared to tell the judge this at your hearing. So just kind of a reminder, as David said, when this needs to be addressed is when you get the 7-day notice or the 30-day notice if you're in default in rent, because AB 486 does apply to 30-day no cause notices and 7-day pay rent or quit notices. So make sure that if you are behind in rent, before you get an eviction notice, is as soon as you can, essentially apply for rental assistance. Now there is no prohibition on applying for rental assistance at any time in this process, but you want to get your application in as soon as possible so you can get your rent paid. So once you've applied for rental assistance and you've gotten that eviction notice, this is when you have to file your affidavit with the court. When it's a 7-day notice, the notice itself does have to be served by a process server or the sheriff. You do then have the 7 days to pay rent, move out, or file the affidavit with the justice court to contest the eviction. You can request mediation in your tenant's affidavit. And then obviously, as we said, raise the AB 486 defense. The hearing should be set either when you file or when the landlord files its complaint, depending on what court you're in. So in some jurisdictions outside of Reno and Las Vegas or Clark County, your hearing might be set when you file your tenant's affidavit. In Reno, in Washoe County and Clark County, your hearing is likely going to be set once the landlord files, because in Nevada, the tenant files first. So you have to file your affidavit as soon as you get that notice. There's nothing else that's going to come from the court that you need to respond to. You have to respond to the 7-day notice. And then if it's a 30-day no cause notice, you need to you'll get the 30-day notice. In order for the landlord to follow through with the eviction, they do need to issue you what's called a 5-day unlawful detainer notice. Once you get that 5-day unlawful detainer notice, that's what prompts your requirement to file your tenant's affidavit. within that 5 days. And again, as I said, AB 486 does apply to no cause notices. So if you are behind in rent and have applied for rental assistance, you can allege an AB 486 defense.
It's also
Again,
important.
oh, sorry, go ahead.
No, it's important to know that, like, if the landlord loses on the 7-day, the landlord may just go the next day and file a 30-day no cause. And that's why this AB 486 defense is so useful, because it's still based on the non-payment of rent. It's just a landlord being prevented from doing that by AB 486. So, I mean, that's why this statute is really good.
Right. And again, your hearing might be set when you file or when the landlord files their complaint, which again, once you get that 5-day unlawful detainer notice, if you've gotten the previous 30-day notice, you do have to file, the tenant has to file first in court to preserve your right to a hearing and raise your defense. And then just remember, these do have to be served by process servers or sheriffs or constables, I should say. So this, I'm just using the Civil Law Self-Help Center form for Southern Nevada as the example, but you can see the self-help forms available. Do have, I said, the checkbox, and should have the ability for you to raise the AB 486 defense, which here it's in the A section. I have a pending application for rental assistance with, and then put the agency where you applied. So in Clark County Social Services, and Reno Housing Authority, whatever it is. You can also allege that the landlord has refused to participate or refused to accept the rental assistance. At the end, as I said, there's also, this is a small box. Our form on our website's a little bit bigger, but you can, explain, the last status update was yesterday and my application was still pending. Whatever it is, to just, kind of supplement that you've been actively pursuing your rental assistance. All right, so once you complete your affidavit, you do need to mail a copy of the, sorry, that should say affidavit, not notice. You have to mail a copy of the affidavit to your landlord. And obviously you have to file your affidavit with the Justice Court. There is e-filing in Las Vegas, Reno, and Sparks. In all other jurisdictions, you're likely going to have to file in person. But you can also call the court clerk to see if there's other ways to file. But do remember, you have to file before that deadline expires. So the 7 days for the pay rent or quit notice, or the 5 days for the unlawful detainer notice if you've got the 30-day notice. You have to file before that time frame expires. So make sure that you know what your deadline is when you get that notice from your landlord. So as I said, a hearing is when the hearing gets set depends on the jurisdiction and how the court operates. In Washoe County and Clark County, likely you'll file your affidavit and then be told that the clerk's office will contact you when your hearing is scheduled if your landlord files. But in all cases, once you file your tenant's affidavit raising your legal defense, you will get a hearing. You should be getting a hearing pursuant to Nevada Revised Statute 40.253 subsection 6. It says shall get a hearing. So just be aware that you need to make sure you're contacting the court clerk's office to stay on top of when your hearing is scheduled. At your hearing, be prepared. Make sure you have notes. This is my defense. I applied for rental assistance. What date did you apply? And when what you uploaded your documents, what the status of your application is, because the judge might ask you to show what you've done to make sure that you're on track to get your rental assistance. And then if you have any other defenses, this is not the only defense. There could be others. Just make sure you're prepared to raise and tell the judge about all of them.
It's important to remind people too that, if you're not used to going in for an eviction hearing, the attitude you should take is I have to prove everything. The court will question you. The hearing master will question you and doubt everything that you're saying. Even if it's not true, you should assume that, because it really helps you prepare. If you have to prove up everything you're saying, I applied for rent assistance. Well, show me proof that you applied for rent assistance. I'm actively pursuing rent assistance. Well, show me proof that you've actively pursued your rent assistance application. So, if you're not used to the justice system, it's stacked against you, and you really have to battle the landlord and the judge or hearing master. And you do that by establishing all the facts that you're alleging.
So if you need to make notes beforehand, do that. And as we've been saying, there's this magical word called legal defense. It's in the statute. All you're required to do in a summary eviction hearing is raise a legal defense in order to defeat the eviction. Judges don't always like to follow that standard and can make a bad decision. If that happens, you do have the right to appeal that decision. And why we're saying it's really important that you say all the, everything, get it all out in front of the judge, make sure that you're the one that's telling the judge what's been going on, because you do need to create that. Make sure you adequately presented those defenses to the court.
Well, let's also sort of illustrate what I'm talking about. Like, actively pursuing is an issue of fact. So if you allege that at the hearing, there has to be some rebuttal evidence, and it can't be just the judge saying, I'm going to doubt you because you don't have money or you don't have a lawyer. So, you will have a defense if you use AB 46, because actively pursuing, if you say you're actively pursuing, that should be enough. But again, the deck is stacked against you, so you should bring in some proof. You should bring in maybe a screenshot of your application if you have it.
Right. Or like I said, make notes of when you've contacted them, dates. If you talk to somebody on the phone, their name, or if you just looked online and checked the status, put the date. I checked the status on X date through my portal and it said application pending. Just make sure that you have that information at hand for your hearing. But if you do lose, you do have 10 days to appeal. It is important to realize, though, that if you want to stay in your unit pending the appeal, you have to appeal before you're locked out. So that means pretty much immediately, unless the judge has granted a stay. So you do need to file your appeal before you're locked out. And in order to stay, you have to post a $250 bond. All that's required, it's fairly simple. We'll get into the differences between Clark County and the rest of the courts that I'm aware of. Because in order to appeal, you really just need the notice of appeal, your filing fee or fee waiver, and the $250 bond. You absolutely need all three of those things, at least when you go to file your appeal. In Clark County, you also must have a document called Statement of Law and Facts on Appeal. That does need to be filed with your notice of appeal and is your legal argument, essentially, why you should be able to stay in your unit, defeat the eviction, why you shouldn't have been evicted, essentially. In other jurisdictions outside of Clark County, it's a little bit different. All you need is the notice of appeal, the filing fee or fee waiver, and the $250 bond. In all cases, though, you have to give the court $250 when you file your appeal, or you still can be locked out. So just keep that in mind.
And I just want to give sort of a practice tip. When I used to defend evictions and I knew the judge was going to rule against me, I would just have those documents ready. In fact, Judge Alstrom said, eviction immediately. So I just calmly walked to the clerk's office, filed my appeal, and the eviction wasn't immediate because it never happens that way. The landlord has to go to the constable or sheriff's office. They have to pay fees. They have to fill out forms. So if you lose at your hearing, you should go and immediately file your appeal, because that will assure you that you're going to stay in your dwelling during the appeal. And Dan Alstrom was convicted felony. He's a convicted felon.
Well, and that just goes to show you, judges are human beings. So they're not some mythical being that never makes mistakes.
That's a good way of putting it.
Mm. And there is a constitutional right in Nevada to appeal every summary eviction order. There is a judge in Washoe County that does not believe that is true.
Right.
But there is a case that says that you do have the right to appeal your summary eviction.
But, he's a human being.
Exactly. And makes mistakes. You do have to pay your rent moving forward. Obviously, if it's AB 46 defense, that's not going to happen. But you otherwise have to abide by your lease. This isn't just like, you still can be subject to eviction for different reasons.
You know, I never really thought about that it's in 40.385, but what happens is you'll get another 7-day notice and you just file your affidavit and raise AB 486. So you really don't have to pay your rent moving forward.
Right. I'd basically say you have to otherwise not get evicted for some other reason.
Oh, right.
Would
Yeah,
be
don't
my-
throw a wild party and
Right.
smash out the windows.
So this is a notice of appeal. It is a very simple document. It literally just says, I am appealing this decision. And the date the decision was issued, and you just file it in your eviction case. This is the statement of facts and law in support of the appeal that you file if you're appealing in Clark County. You do have to summarize the evidence that you present at the hearing, which is why we're making such a big deal about what you told the judge, what documents you supplied the court, what you put in your tenant's affidavit, because that's going to be what's relevant for your appeal. If you don't say anything in your hearing, you know, you do still have your affidavit, you still have what you filed, but you're going to have a harder time if you don't make sure that you explain all your defenses to the judge. And then the legal issues presented and why you're entitled to relief. This is just why the decision was wrong. Why was the judge wrong? I actively pursued my rental assistance. I should have, you know, the judge should not have evicted me because of AB 46. There could be other reasons, obviously, but it's really just why you should not have been evicted.
Right. But, you know, there's a couple of hints too. And I would not check the box if you want to attach additional pages. I would try to boil it down to the 4 or 5 lines that you have there. And I know it's important to people. You want to include everything, but you really, there's going to be a loss of interest if you include additional pages. The other thing, which of course I do this too, is make sure that when you write this out, it's legible. And you know, my handwriting is terrible, but you know, try to make it. You use capital letters, block quotes, whatever. Just try to make it legible, because if the judge can't read it, you're not going anywhere. You're not going to win.
And it is important not to, I know that people, you know, they feel wronged. They want to get out everything that happened, all the bad things the landlord has ever done to them. Do not do that. Do not go through why your landlord is such a bad person. You want to stick to what the legal defense is. And we've been talking mostly about AB 486, but this can apply to any of the legal defenses that you raise at the hearing or in your affidavit. You need to stick with the judge violated AB 486. The judge violated NRS 40.253. Whatever it is, don't go into all of this, you know, diatribe against your landlord. That's not going to be relevant. And as David said, the judge is going to lose interest. And this does say Las Vegas. It is Clark County. So Las Vegas, North Las Vegas, Henderson, you know, Clark County, essentially. All right, so you filed your notice of appeal in Southern Nevada. You filed your statement of law and facts on appeal. You've posted your $250 bond so you can stay in your unit pending your appeal. In Clark County, the district court judge will make a decision on your appeal fairly quickly, and you will not get a hearing. So that's why it's important to make sure in that statement of law and facts on appeal that you do get, you know, in clear terms what happened at the hearing and what your legal defense is, because that's basically all the judge is going to look at outside of what's actually in the court file from your appeal itself. I mean, from your eviction hearing itself. In other courts, so outside of Southern Nevada and Clark County, as I said, you only file the notice of appeal, your $250 bond, and the filing fee or fee waiver. You then have obligations after you file a notice of appeal to file other documents. So we're going to talk about the Justice Court rules of civil procedure and some of the rules that do require you to do certain things at once the notice of appeal is filed. It is likely, though, in almost all cases, well, especially in Washoe County, You are also probably not going to get a hearing. So it is important, again, that you put in the documents that you file as clearly as possible what your legal arguments are. But in courts outside of Clark County, you may need to get a transcript of the hearing. If you can't get a transcript of the hearing, you can file a document called the Statement of Evidence or Proceedings. And that can be from your memory. Again, it's potentially the same thing as what Clark County calls the Statement of Law and Facts on Appeal. You just have to lay out what your recollection of what happened at the hearing is. Again, what did you tell the judge? What were the defenses you raised? What did your landlord say in their defense? So you do want to make sure that you either get the transcript ordered, which has to be ordered 10 days after you file the notice of appeal, or file the Statement of Evidence or Proceedings based on what you recollect if you are unable to get the transcript.
It's important to also point out how unfair this process is, how they just unfairly discriminate against summary eviction appeals. First of all, briefs aren't required. And if you don't have a brief, you have nothing in the district court to review. So it pretty much means we're going to rubber stamp whatever the lower court did. The other thing is, if you do have the precious right to file a brief, it can be only 10 pages long. So it shows how this system, these rules, the whole process is really stacked against the tenant. And if you can survive and win, you've really accomplished something.
And there is a process for submitting additional documents. As David said, it's not easy to do. You do have to remember to do these things, and there are deadlines. Generally speaking, you have, once you do the Statement of Evidence or Proceedings, you have to mail it to your landlord. Your landlord has a chance to object. But if they don't object within 10 days, then you file that with the court. Then you can also file a statement of points, which is, again, the legal basis for the appeal. So it is a similar filing to that Statement of Facts and Law and Appeal that you file in Clark County. It's just done slightly differently. But you need to file the statement of points, and it does say concise in the rules. So again, you want to be, direct and clear what your legal basis is for filing the appeal, which is why you should not have been evicted. Why the judge's decision was legally wrong, not why your landlord is a horrible person, not why your landlord has violated your rights the whole time you've lived there, but why the judge made an incorrect decision based on the law.
And if you're outside Clark County, it's difficult to get through this appeal process because, you file your notice of appeal, you post your bond, you think you're done. In Clark County, you pretty much are. But in other jurisdictions, you have 10 days later these requirements, and you have to order the transcript or provide the substitute for the transcript. You have to do the statement of points. So, a lot of times your appeal, even though you filed on time, could be dismissed if you don't follow the procedure, the appellate procedure.
Right. And then what happens is the Justice Court actually has a duty to submit what's called the record to the district court. This can happen the day after you file your notice of appeal. In Clark County, that might not be an issue because you filed everything you need to file when you file your appeal. In other jurisdictions, this can be a problem because you have 10 days to request a transcript or submit the Statement of Evidence or Proceedings. The Justice Court might have already submitted that to the district court. So you do need to try to figure out where the file is, because that's where you need to file your subsequent documents. You can file them in the Justice Court. The Justice Court is required to transmit that to the district court. But if the file has already been transmitted and the district court has the case file, you're probably better off just filing those with the district court. But again, I would suggest you file a statement of points because again, you might not be able to get a brief, and we're going to talk about briefs in the next slide. That is your only basis for getting your legal argument before the judge.
Well, let's point out too, in rural areas, the Justice Court could be hundreds of miles away from the district court, and you got to travel there to file these documents.
And just remember, the notice of appeal, all of your appeal documents should be filed in Justice Court.
Right.
So it should be filed in the
Until
court.
they transferred, and then they're filed in district court.
Right. And then once they transfer to the district court, then things get filed in the district court. That includes any briefs that might be due. That the brief is absolutely filed at the allowance of the judge in district court and with the district court. So in Clark County, you likely won't be able to file a brief. In other jurisdictions, it is up to the judge. We always request briefing when we file appeals. Normally, the judges allow briefing, but in your statement of points, make sure you put in there at the end, I request the ability to file a brief so that you have that on record. It is up to the judge, though, whether they allow you to do that. And as David said, it can't exceed 10 pages or 7 if it's handwritten.
Stop right. Who wrote that? I mean, when you type, it's less pages.
Right.
So basically, they're discriminating against people who don't have typewriters or word processors or an attorney. 7 handwritten pages. It's just, sometimes you can be unfair and not realize you're unfair. And I think this is one area that they're completely unfair.
And again, even if you file outside of Clark County, you're likely not going to get a hearing. If you want a hearing, you need to request that, put it in your brief that you want a hearing. That's not guaranteed to work, but it is possible that the court will grant you a hearing. It's always up to the court, always up to the judge how they want to handle it. So just, a final, what is your legal argument? Remember, the legal defense must be raised in justice court to win on appeal. So did you present the justice court with a material issue of fact or with a legal basis to deny the eviction? And we want to make the point about the material issue of fact because there is a Supreme Court case, and that's the Anvui versus GL Dragon case that basically said that a legal defense can be a genuine dispute as to a material fact. So when David said, it has to be more than just the judge saying, I don't trust you because you're poor or you didn't pay your rent. They're actually, if there's a factual dispute, then you should be able to, that should be a legal defense. Of course, AB 486 allows you to raise a legal defense based on your active pursuit of rental assistance. So it just, make sure that you're raising all of this in your hearing.
It's absurd, really, because who's going to rebut I'm actively pursuing? You'd have to get the entity that's dispersing the rent assistance to come in and say, no, they haven't. We emailed them and they never respond. You're always going to win on that because there's no rebuttal evidence.
Right. And as David said, the issue of good faith or active pursuit is an issue of fact. It is extremely important that you get that out at the eviction hearing itself, because the eviction standard is that, a genuine dispute is to a material fact. On appeal, the justice court gets deference on findings of fact. So your appeal is not a chance to rehash what you said at your eviction hearing. It's only whether or not the judge made an incorrect decision based on what happened at the hearing. I don't know if that distinction came out correctly because in my mind, I don't know if I'm saying it correctly, but you have to make sure that you're raising all of this at the hearing.
You're right, Ray, but there's no evidence that you didn't actively pursue or you
Right.
didn't show good faith. There's absolutely no evidence other than the prejudice against you.
Right.
And that's not, it's not yet been
Right.
held to
Well,
be.
and that's the thing is there is no dispute of fact because you're the only one that supplied any facts.
Simple for us, but difficult when you want to rule against the tenant.
Right. And then if the rental assistance is paid, the judge is supposed to dismiss the eviction. If the landlord is thwarting your ability to get rental assistance, then they're supposed to deny the eviction. So, again, just make sure that you've got all of this that you're raising in your actual hearing, because on appeal, you're only arguing the law. You cannot rehash the facts. And then some information about where to apply for rental assistance. But that pretty much concludes our presentation on AB 486, appealing and what to do with summary eviction. Any final thoughts, David?
Yeah, again, I've been saying it for a long time, but apply for rent assistance. Some people may have given up hope or just are depressed about the circumstances, but applying for rent assistance, not only will it pay the rent, but it could also help you if the landlord tries to evict you.
Right. All right, I'm going to see if I can check and see if there are any questions. If you have a question, please go ahead and put it in the chat. Unfortunately, this might trigger some noise, so just bear with me. Yeah, there we go. Well, so far, no questions in the chat. I will go ahead and put up our last slide, which is our
Contact information.
contact information. Yes. So our website and our toll-free phone numbers for you to contact us if you are a renter facing eviction. But as David said, this is a complicated process. So just keep that in mind that, you know, even lawyers have trouble with this. So
hearing masters and judges too.
yeah, well, obviously the judges have trouble with this. So it is not an easy process, but you know, if the judge does decide that you should be evicted, even if you apply for rental assistance, please keep in mind that, you know, you might have the right to appeal.
And I was looking at the Dayton Justice Court, and they actually have an affidavit that includes rent assistance as a defense. So it was nice to see.
Yes. Well, still no more questions. So we'll go ahead and call it for today. Thank you, David, and thank you for all of those who attended.
Thank you.
Have a great rest of your day.